the question, did Karmelo's prosecutor hide the evidence? And if not, then who did? Everybody thinks that there's missing evidence. We are going to, we're gonna talk about that, right? Everyone is saying, where's the footage? Where's the blood? Where are the fingerprints? So let's get into all of that today. And I'm gonna show you how evidence works, and I'm going to show you 7 places where the evidence can vanish, right? Where it can go. I'm not going to say poof like a fart in the wind, but it can fail to continue along in the process. And some of them are legit, and some of them are less legit. And we're gonna go through all of that. Okay. All right, so I tried to think, what's the easiest way to break this all down? What's the easiest way to show the flow of the evidence? And I think I got it all down into one thing. So the first thing that we need to know is that there's the body of evidence that exists in the world, and then a much smaller subset of that is the evidence that ends up in the case. So the question is, what happens to that big universe of evidence, and how does that big universe of evidence get minimized to the little bit of evidence that shows up in the case? And there are some real answers to this question. Okay, so the first thing is, the entire point of the rules of evidence is to show the trier of fact, right? And that is generally the jury in a jury trial. If it's not a jury trial, then it's the judge, right? So we have rules of evidence that govern the admissibility of evidence, right? And so a huge reason why a large portion of evidence is at the beginning, and then by the time it gets to the jury, there's very little. And I'm going to show you all the ways that happens, but one of them is the rules of evidence, right? And the entire point of the rules of evidence is to show the trier of fact, and that's just a term of art. It means the jury, if there is a jury, to show them only the evidence which is most likely to help them reach the right decision, right? Which is the truth, right? They are supposed to sort through all of the evidence and find the truth and minimize the risk of error, right? So these rules are assembled for that specific purpose. So let me introduce myself. If you guys have not met me before, my name is Gray. This is my channel, Counsel Gray. I am a practicing attorney. And this whole channel is to walk you through the legal aspects of cases that are in the news, but not just the legal aspects, but also the trial strategy that the prosecution or the defense might be using, right? So when prosecution and defense, they look at a particular rule, they are thinking strategically very differently about that rule, okay? Okay, so I'm going to show you 7 ways that evidence completely vanishes. Okay, so you're going to be particularly interested in numbers 3 and 5. And I'm going to tell you what each of these steps is, what happens at each of these steps, how defense and prosecution and the court will behave at each of these steps, and you'll see. So I want you guys to be thinking about, if you're one of the many people who thinks that there is missing evidence, whether it's missing footage, whether it's missing fingerprints, whether it's missing, blood on the weapon, blood on Karmelo, whatever it is, right? And a lot of people have a lot of different theories. They want to know, where's this evidence? I'm going to just show you what it is today, and I'm going to let you guys decide for yourselves. Some of these conspiracy theories have been debunked, but people are still holding on to them. And at the end of the day, I don't know what's going to happen in this. I don't know what's going to happen in this case, because I think that we are about to see some shockers. We are about to see some shockers when this appellate team gets on this case. I don't know what's going to happen. A lot of stuff we will not know until. So here are the 3 records of any case. Okay. There's the transcript of what happened during the trial. There's also the computer docket, which is basically just an electrical, the court clerk will type in important things that happen, like the jury was sworn in today. The defense asked for an extension, right? Those kind of things. And they usually go in just a couple of sentences. And it's really just so that when you go back and look from the court standpoint, you can kind of see what happened. Now, there's a third, much bigger record, and that is the record that the defense counsel is going to get. And what that's going to include is going to be the transcript, the docket, it's going to be some evidentiary files, but it's also going to be a record of all of the motions made and what happened on them, right? You will not see motions made in the transcript, and you will not see motions made in the docket. So there is, you guys keep in mind, there is this other big piece of evidence that we will most likely never see. And that is all the motions, all the filings, the pleadings that have been sent back and forth in the case, okay? We can try to glean what they were, but we will not see them. Okay, so as I was saying, evidence vanishes as we go from this big pink circle, right? This is your nested Venn diagram. There's this huge universe of evidence that exists in the world, but there's this tiny little circle of evidence that ends up in the case. And the question is why? And I would say, I didn't put it on here, but there's an even smaller circle within that yellow circle, which is what gets released to the public. So what we're doing is we're looking at what was released to the public. We're trying to put that together with what we heard about the testimony, right? Because remember, the trial was not public, but there were spectators allowed in, and a lot of them took notes, and then, it was going out to, 25, 30 different channels, right? And so we're trying to put together all of this stuff that happened. There's so much more. Okay? So let's go back and look at the 7 possible ways that evidence vanishes, okay? And you're going to like numbers 3 and 5 when I explain what they mean and what a lawyer would do with them. Okay? So let me just say, here's the desired timeline. And you guys, when you look at these types of evidence that I'm about to go into, I want you to be thinking about this. The job of each party is to narrow the focus, this whole long timeline of events from the day that the accused and the victim were born up until, right, this whole long period of time. Each party wants to narrow the timeline to those issues, to those incidents which most support their case. Okay? So if you look at if you look at the slide that I have up, okay, so the top line, the blue line, is what the prosecutor wants, okay? The yellow line is what the defense wants, okay? And that big that big bam in the middle, that's the incident, right? That was the moment that Karmelo did whatever he did, or whoever did whatever they did. That's that moment, okay? So the prosecutor wants you to focus on everything that happened after that, and they want to limit your focus on what led up to that moment. But instead, right, instead of looking at what happened under the tent, how they got to the tent, how they were, the weeks before and the days before, and what their reputations were and what their school habits were, the prosecution, which is that top blue line, they're like, none of that matters. What matters is the moment that Karmelo decided to do what he did, and after, right? So when they show him running, right, they spent more time showing him running away from the incident than they did in the incident, right? And the reason that they would do that, and again, I don't know why they do that, but I can tell you why a prosecutor would do that, is because they're trying to show that whatever happened after the event means something. You can read into it guilt or innocence, or you can interpret his words, or he ran so fast, therefore this or that, right? That's everything after is what that means. That's what the prosecutor wants you to focus on. The defendant, on the other hand, wants you to focus on everything that led up to their client doing what they did, right? The defense is like, wait a minute, this didn't happen in a vacuum. A bunch of stuff led up to this moment. And so what the defense wants you to do is they want you to focus on everything that led up to the event. And so when it comes to the kind of evidence that they're looking at and using, right, the defense is going to want to bring in evidence that shows the past. What led up to this moment that made my client do this? It didn't happen in a vacuum, right? The prosecution in this case is going to say, it doesn't matter what happened before. It doesn't matter if they had a previous relationship. It doesn't matter what their respective, reputations were. All that matters is the moment that this guy decided to delete our, this poor victim, right? So, and I put on there, and sometimes the reverse, right? Because sometimes it's the opposite, right? The prosecution wants to show you everything before the incident, right? And the defense is like, that doesn't matter. Let's focus on, what happened and then what happened after that, right? So let me give you an example of that. The prosecution is trying a guy for sending some woman packing. The prosecution is going to say things like, for 6 months, he stalked her, right? For, 3 months before the incident, he was doing Google searches for. The defense is going to say, well, maybe, but that doesn't mean that on this day that he's the one who sent her packing. Right. So they try to narrow people's attention to the time frame that they want. And sometimes there's significance to that, right? Sometimes what happens before or after is significant. So if one of the two parties is successful in getting that part out, then they win. And let me show you how they do it. Okay, and you guys go ahead and subscribe, like, comment, subscribe so that you can leave a comment, because I am going to get to these comments. Like, subscribe, share it out on your timeline, and also send a super chat. I appreciate the support that you guys have given to the channel, right? I'm having a lot of fun doing this. Okay, so as we look at this evidence, I want you to be thinking, which party has the most interest in getting it out, right? So for example, if there was a history, right, a lot of Karmelo supporters say yes to the afterlife. A lot of Karmelo supporters say that, this kid had been a bully. He had a history of being a bully. He was a known bully, right? So the defense would be interested in bringing in this evidence, and they would have reasons for it. The prosecution is like, it doesn't matter if he was a bully on this day, right? Okay, so I want you to be thinking that as we go through the rules, okay? So here are the 7 places where evidence moves along the channel, okay? So the first sort of phase of evidence is all the evidence in the world. Everything that exists that could or could not bear on this case. And then you split that in half, and you have everything in the world that could bear on this case. And then you have all the other stuff that's totally irrelevant. Okay. So some portion of that big universe of evidence, some portion of that is going to be received, collected, and processed by the police. So I'm going to walk you through these 7, and then I'm going to show you how evidence gets eliminated, right? How this circle gets smaller and smaller and smaller. Okay, so the first stage, like I said, is all the possible evidence in the world. Some of it pertains to this matter, some of it does not. So the next phase, which is a narrower phase, that is that portion of evidence which is received by the police, either because someone brought it to the attention of the police, it was collected at the scene and processed by the police, right? You see that as a much smaller set of information. Okay. The next thing is the prosecution's entire file. Okay. And that is documents, witness testimony, evidence, blood results, blood samples, right? Everything that they've got, video footage, cell phone footage, it's everything that they've got. The next place where that shrinks is what percentage of what the prosecution has do they disclose to the defense? And a lot of people feel like they did not disclose enough to the defense. And I'm going to show you where you might be right, but then I'm going to show you where even if they had disclosed it, that still doesn't mean that it would get to the jury. And even if it did get to the jury, that still doesn't mean it would get to us, the public. Okay? So now the prosecution has disclosed some subset of everything it has to the defense. And I'm going to tell you what it would and would not disclose to the defense. So the next place where it gets a little bit smaller is what percentage of that information that has been shared between the parties gets offered by either side at trial, right? So the prosecution has this big, robust file. They're going to disclose some subset of what they have to the defense. And then the body of evidence gets even smaller because the defense and the prosecutor, they still may or may not offer it at trial. Just because the prosecutor has it doesn't mean they have to use it at trial. Just because the defense has it doesn't mean they have to use it at trial. Okay, so now we've got a much smaller body of evidence of what is offered at trial. And just because it's offered, right, you see this circle keeps getting smaller and smaller. And I'm going to show you why in a minute if you just got here. Just because they offer it at trial does not mean that the jury is going to see it, right? Because what happens there is that the judge can say that this is not going to the jury, right? This is not helpful or useful to the jury, or it will not help them get to more of a right answer. Okay. And then the last thing, even what the jury sees, that doesn't mean that the public will see that. There still can be another cut before the public sees it. And there are various reasons for that. Some of it could be to protect some of the parties. Some of it could be because it pertains to another ongoing matter, right? Okay, so let me go back and walk you through each of these phases and show you how these different baskets, they're really more like a sieve, right? Every time you dump a glut of evidence into one of these 7 places, a little bit seeps out the bottom, right? It's more like a sieve than it is like a bowl. Okay. All right. Okay. So you guys, again, tell me what you think. Tell me what evidence you think is still out there. Tell me who you think hit it or whatever you think happened to it. And let's see at the end, let's see if people are right. I'm going to go through the comments later. Okay. So tell me what you think in the chat and I'll get back to those in a minute. Okay. So, and you guys, I'm sorry that some of this is small. I hope you guys are watching this on your laptops. Okay. So we started the first phase of evidence, right? Is this big universe of all the possible evidence in the world. Some 99.9999% of it has nothing to do with this particular case, but there is this body of evidence that exists in the world related to this case. How does that go away? The first way that body of evidence that pertains to this case already gets smaller is because it's never found. The police never find it, right? They never find the murder weapon. They never find any fingerprints. They never find a particular witness who may know something, right? Some of this evidence will just never be found, right? The second thing is that it's unknown. Nobody even knows that it exists to go looking for it. So if you don't know that it exists, you can't send somebody out to find it and bring it back. Another way is there's no snitching culture, right? No snitching culture, or people who just don't want to get involved. They don't want it to come back on them, so they say nothing, right? You hear those cases where people came back and they said, 30 years later, yeah, I was there, I saw everything, I was afraid to say anything, right? And they hold these secrets, right? Yeah, it was my girlfriend, it was my boyfriend, he told me if I told that my whole family would be in trouble, etc., right? So there's this idea that people don't snitch. There's this idea that people don't come forward for their own reasons. And sometimes people are the critical witness and they literally don't tell a single soul for like 30 years, right? So this is how the evidence that exists in the world can just not make it into the process. Like it just never, ever materializes. Okay, so here's the second thing, right? So when we talk about evidence that is actually received and collected and processed, we still lose some of that evidence before we get to court, okay? The evidence can be lost, right? You guys, I'm sure, have heard of evidentiary files getting lost, whole boxes getting lost, right? Stuff just gets lost. Sometimes it gets intentionally misplaced. Now, some people may be thinking in both of these cases, in number 1 and number 2, some of you may be thinking that there are witnesses who just are not saying anything, or people are just not saying what they saw. A lot of people think that, right? Some of you may be wondering whether or not they captured the cell phone footage from the students. We don't know, because we don't know where in this process the cell phone footage, if it exists, would have fallen away. The cell phone footage, right? People think that there were so many kids in that tent, and I tend to believe that there were, you know, at least a dozen, maybe 2 dozen kids under that tent, and I'm sure someone was on their phone, had a phone, and these kids, their phones come out so fast, right? All we know now is that the cell phone footage is not there, right? It has not materialized to us, the public. It could have fallen out in any of these 7 steps, okay? So when you think about the piece of evidence that you're looking for, ask yourself, where is it most likely to have fallen away? Okay, so in step number 2, stuff gets lost, stuff gets mishandled and therefore is unusable, stuff gets logged by the police. They have technical errors. Sometimes someone forgets to log it home. There are cases where officers take a file home to work on it overnight, and then when they bring it back the next morning, inadvertently something is missing out of the file, right? So then out of this body of information, all of this goes then to the prosecutor's office. Okay, and the prosecutor will have been receiving information from other places, from the school, from different subpoenas that they may have sent out, or requests for information. They may have private investigators, right? We don't know. But what we do know is that the prosecution has this entire file of evidence, regardless of where it came from, most of it from their law enforcement investigators. And then they also have this thing called Kyle evidence, right? Now, Kyle evidence is evidence that is constructively known, and that's kind of a legal standard of knowledge, right? It's constructively known by the prosecutor, right? They may not exactly know it, but they have reason to know that it does exist, right? It's like you should know, or they have reason to know, right? That's what constructive Kyle evidence is, okay? So now the prosecutor has all this information. This is the prosecutor's file. So for those of you who think that the prosecutor is hiding information, this is where it would be happening in step 3, right? Because in order to say that the prosecutor is hiding information, you have to say that they had it and chose to look the other way. If for some reason the police had it and chose to look the other way, the evidence would never have made it past step 2. But if you think that this prosecutor is hiding information, that means that it was handed to the prosecutor, but the prosecutor has somehow misplaced it. If you think that there's some kind of a cover-up, or evidence has been destroyed, or whatever it is, by the time it gets to the prosecutor, it has already gone through police hands. It has already gone through the police lab. It's already gone through investigations. It's already gone through forensics. It's already gone through a lot of things. So for it to disappear from the prosecutor would mean that more people are in cahoots than just the prosecutor, right? If you really want to make the argument that the prosecutor is hiding knowledge that it has, remember, the police and law enforcement are the investigators. Now, the prosecutor has its own investigators, but the prosecutor only has what the investigators gave them. So for the prosecutor to then say, well, something vanished, law enforcement can easily say, unless they're in cahoots, law enforcement can easily say, nope, we gave that to you. We gave it to you with a chain of custody, right? So they'd have to be in cahoots. So if that's your theory of the case, then stick with it. But realize, and I've said this since the beginning, that it takes more than one person to stage a cover-up. And the further you get down this path, right? We're only on number 3, and we already have multiple people that would have to be involved for this to be a prosecutor hiding evidence, okay? But there are still a lot more places where this thing can disappear. Okay, so now The prosecutor has to decide out of his whole big file, what of this evidence am I going to turn over to the defense? And there's a lot of rules right here. Okay. Remember, like, subscribe, comment, super chat, do all the things. Tell me how you feel. Tell me what you think in the comments, because when I finish this, I'm going to get to the comments. Okay. So tell me how you feel. Okay. So here's a lot. This is number 3 is the biggest one. Okay. So this bottom row, just so you're clear, is what could possibly leak out at this phase. Okay, so at the top, we're in phase number 3, and that's where the prosecution has this big file of evidence that they've received and collected from the police, the evidence lab, blood work, fingerprints, etc. All of this is turned over to the prosecutor. Now the prosecutor has to decide what to do with it. He decided to file charges, and here we are. So the next step would be, what percentage of that gets disclosed to the defense? And here's the answer. The prosecutor does not turn over, or let me say this. This is a better way to say it. If the body of evidence that the defense receives from the prosecution is smaller than what the prosecutor has, here's why. 1, the prosecution withheld Brady items. Now, Brady items are, and I think I did a community post about this if you want to know what it is. Brady, US v. Brady, it's a Maryland case from the 60s. And basically it says that a prosecutor must turn over any evidence that is exculpatory to the defense, right? Meaning that it tends to show that the defense is innocent, or at least needs to be investigated for such, or that impeaches a prosecution witness. Any of that kind of evidence must be turned over by the prosecutor to the defense without asking, and there's no limit on the time. Whenever the prosecutor gets it, if it's early in the process, after the process, during the trial, after the trial, that evidence must be turned over to the defense. So this is what people think. People think that he did not turn over this evidence to the defense, okay? And that is possible. Now, how do we see this in real life? Okay, these are these old cases that you hear about that get overturned after like 30 years, when it comes out that the prosecutor knew that the witness had recanted their story and said they only told the story so they could get some drugs, or they only said that this guy did it because someone else threatened their wife and kids or something like that, right? That's the right. So what the prosecutor will then do is say, no, man, we got this. Like, we're too close to this thing. And they'll say they don't believe that person, right? Or something like the eyewitness had originally identified somebody else, right? You need to tell the defense that the accused was actually the second or third person that this eyewitness identified, right? She was so sure that it was this person, or he was so sure that it was that person, before settling on your client, right? So when we hear these miscarriages of justice, right, these travesties, it always comes out that the prosecutor had some little piece of information that they didn't turn over, and 30 years later they're going to deny that they had it, or they're going to say that they did turn it over, that it was in the file, etc., blah blah blah, right? But that is Brady evidence that's not turned over. Okay, so let me put that back in context. Out of this big body of evidence that the prosecution has, one reason that what the defense gets is smaller is because the prosecution does not turn over Brady material. That is a violation. That is a constitutional due process violation of the accused. Okay, that is a major. First of all, it's grounds for a retrial fast. Okay, all right. So the second reason is that, and this is a strategy play, this is a faux pas on the part of the defense. Number 2, the defense did not request the information, right? So if you've ever read a discovery request, that means that the defense literally did not think to make a discovery request. Now, discovery is governed by a whole different set of rules. But if your defense counsel is sleeping and they don't think to ask for something, the prosecution may just not turn it over. They may say, well, You didn't ask for it. You didn't have a comma in the right place. You didn't put a catch-all on the end of it, right? So these are the kind of things that, like, the defense will ask for, and this is true in civil and criminal, right? They'll ask for anything related to this, including but not limited to this, and then they'll put on the end, and anything that we forgot to ask for, or anything relevant to this matter, or anything similar, etc. Right? If defense counsel is sleeping and they forget to ask something, and the prosecution recognizes that, they're not going to hand it over unless it's mandatory Brady. But if they're in the business of holding Brady information anyway, they're just going to hold it. Okay. The next thing is, and these are litigated by the judge even here. Okay. The prosecution will not turn over any evidence that it believes to be privileged, that it believes have no bearing on the case. So the prosecution may say, hey, we came across this information while researching Karmelo's case, but this is privileged information, so we're not going to turn it over. Or this information has no bearing on the case, so we're not going to turn it over. Well, the defense may feel differently if they saw it, right? So sometimes number 5 here is that the judge will exclude it, right? So if the parties cannot agree on whether or not this piece of evidence is something that the prosecution should hand over to the defense, they will go before the judge and let the judge decide. Okay. And then the judge will decide, based on what I said before, is this likely to help the jury find the right answer? And the judge will weigh it back and forth. Should I have the prosecution turn this over, or should I just say that the prosecution does not have to hand this over to the defense? Now, some people are saying that the defense requested, and we won't know this because we don't have access to the motions. Some people are saying that the defense requested access to Austin and Hunter's background, right? Any fights they had in school, any accusations in school, etc. And the question is whether or not that information was ever turned over to the prosecution's office. Now, some people are under the belief that oh, thank you. You're doing a great job, Counsel Gray. Thank you. Some people are under the impression that the school district did not have to turn over the school records of the boys. This is not necessarily true, right? So some people think that this is FERPA protected information, and we did see some wrangling back and forth about FERPA in the trial docket when we went through there. But here's the thing. In 30 seconds, basically what FERPA is it says that any school that's federally funded, right? This is a federal statute, and it basically says any school that receives federal funding, right? So what that does is it eliminates certain private schools, certain Catholic schools, things like that, right? If we're not paying for anything that you do at your school, we can't have jurisdiction over you, right? But if you do receive money from the federal government, which most public schools in America do, then this rule applies to you. And it basically says that a school cannot turn over certain student records to a third party without the family's consent, etc. But there is a carve out which says that they can and they have to in response to a duly ordered court subpoena. Okay. So we don't know, right? So what we saw in the docket, for those of you that watched the docket video, if you didn't watch the docket, go back and watch that docket video, because I walk through the whole entire docket. We see all the subpoenas that were made by both sides. Go back. Okay. So what we don't know at this point, right? The appellate counsel will know, but we don't know because this has not been released to the public. As far as I know, it's just rumor. Okay. When there is a court order, the rules of having to get family permission are relaxed and things like that. So we don't know whether or not the school turned over the records, and the prosecution may have turned them over to the defense or not. All we know is that or all we believe is that they never went into the evidence. Okay. So we don't know the status of those school records. Now, here's the thing. Remember when I said, let me back up. Remember when I said, and I'm just going to back up for a minute here. Remember when I said about this timeline? In this particular case, the prosecution wants to start at the moment of the incident and look forward. The defense wants to start at the moment of the incident and look backwards. So which one of them do you think would be most interested in any records of the twins' bad behavior and reports at school and things like that? Obviously, it would be the defense. The defense would want to go back and look and say, are these kids who have a history of bullying? Are these kids who fight a lot? And they also would want to say, while looking back, oh, and by the way, look at Karmelo. That boy's clean as a whistle, right? He's the captain of this. He's the captain of that. He's got scholarships. He's already been accepted to this and already into that, right? He's got scholarships here. He's got this GPA. So they want to see both kids' records, so they can show that their kid is the angel and the other two kids are the villains. The prosecutor doesn't want to go back, right? So the prosecutor is not going to really fight hard for these FERPA records because he doesn't want them. They don't help his case. All they do is they show that his victim may have, depending on what they said, right, may have had anger management issues, and they would show that the accused was a good kid. So the prosecutor's not going to fight for these FERPA records, okay? But again, we don't know whether or not anybody ever got the FERPA records, right? All I'm saying is that it is not, there's a lot of people saying that there's no way for them to get these FERPA records because the school does not have to release them. The school absolutely has exceptions for when they have to release these records, okay? All right. I can't remember where I was, but anyway, so at this point, so if the prosecution and the defense can agree in moving from 3 to 4, if they can't agree what evidence should flow, then number 5 right here says that the judge would decide, and whatever the judge decides to exclude, the prosecution does not have to hand over to the defense, okay? So now we've got this really small body of evidence, right, which is the prosecutor's big whole huge file. And now it's been reduced down to whatever he disclosed to the defense. Now, again, if the defense forgets to ask for something in discovery, if it's not Brady information, the prosecution does not have to volunteer it, right? They don't have to turn over everything. They just have to turn over Brady material and whatever the defense asked for in discovery, as long as the judge didn't overrule the request. Okay, so now the defense has a smaller set, okay? From that, how it gets even smaller is that just because the defense and the prosecution have it does not mean that they have to try to use it in court. They may decide that out of these 100 pieces of evidence that we've got, we only really want to use 30 of them. So now that 100 pieces of evidence has now shrunk down to the 30 that they want to use in court. Okay? So here's what happens once the defense and the prosecution attempt to use this information at trial. And that can happen before trial, in the lead up to trial, right? So before trial, there's a lot of motions back and forth between the parties, which again, only the appellate record will have. We don't have, that has not been released to the public, okay? At this point, there's a lot of back and forth between the parties and the judge to say what actually goes in front of the jury. Okay, so for example, the prosecution will say, we want to use these pieces of evidence in the trial. The defense may say, okay, we agree, or the defense may say, no, we protest, or we don't want that, we don't believe that evidence is admissible for this reason. And the prosecution and the defense will argue, and then the judge will decide what evidence can be used in trial, and vice versa. Sometimes the defense will want to use a piece of evidence that they have, and the prosecution will argue, no, here's why we don't think it should be admissible. They do a little trial back and forth, and then the judge decides. So a lot of things that people think that the defense counsel did not use, They may just have not been admitted. The judge may have said, this is not admissible. And why would the judge say that? Because the judge believes that it's not going to help the jury come to the right conclusion. Now, I don't have to say anything other than that because you can see the problems inherent in that. Some people would say, let the jury see everything and trust the jury to sort through it and figure it out. Like, judge, we don't need judicial intervention. And a lot of judges are more liberal and a lot of judges are more conservative, right? Some judges will say, I'd rather send it all to the jury and let them figure it out. Other judges will block it before it ever even gets to they'll say, no, that's going to confuse them. That's more, here's a sort of classic evidentiary rule. I'm not going to admit that because it's more prejudicial than probative. Meaning, to introduce this, while it may be relevant, it might actually be relevant, but it will be more harmful to one of the parties than it is helpful to the final decision making. Okay, so this is where a lot of otherwise relevant information falls away. Or the judge may say that it's not relevant, right? Or the judge could say, yes, I agree that this is relevant, but it's more prejudicial to one of the parties than it is probative to the process. So between step 3, where the prosecutor decides what to hand to the defendant, and then step 5, when the judge decides what information goes in front of the jury, those are 2 big areas, right? So judges have viewpoints, right? They have points of view. They are elected officials. They are elected by party, right? So in not all places, right? In some places they're appointed, right? But they have a point of view, right? Some of them are tough on crime. Some of them believe in a lot of judicial interference. Some of them believe in judicial hands-off, right? Again, a judge who's very hands-off is going to say, I err on the side of showing it to the jury and letting them decide. Someone who is less permissive and more conservative might say, no, I'll decide right here, right? I'll intervene and I'll weigh in on what I believe. Okay, so a lot of information can get blocked at that point, right? And again, I want you guys thinking about the evidence that you're looking for, the evidence that you think got missed. Where in these 7 steps, where in these 7 steps do you think this information fell away? Hang on one sec. All right, you guys. So I just when you guys are going back and forth about what you think, what you heard, a lot of these rumors are nothing but rumors, okay? And I can tell you every single thing that people are saying, it is hearsay. And that's maybe what makes it so interesting. Maybe that's what's keeping this thing alive, you guys, but it is hearsay. It is 3rd and 4th hand information. Unless you yourself read the transcript, and right? You cannot say what was said in testimony. All you can say is what you heard some trial watcher say. And half of them, and I watched a number of them, half of them were stressed out and fumbling over their words, right? These are not court reporters. They are not stenographers. They are not little old ladies who remember shorthand from the 40s. So there's a lot of, oh, well, it was testified to on the stand. Well, right? Nobody knows what was testified to on the stand until we see that transcript. Until we see the transcript. So you guys can go back and forth trying to prove all your points based on that, but and if you believe it, right, if you heard it from a trial watcher that you believe and you think you've heard it in multiple places from multiple, that's fine. But you have to also acknowledge that you are spewing 2nd, 3rd, 4th hand information at this point. And not act like it's fact, like you heard it from the horse's mouth, because you didn't, unless you were in that room, unless you are one of the trial watchers, unless you are the stenographer. Unless you are the stenographer, and even stenographers make mistakes. There are some big cases involving stenographers who omitted one word, who left out a comma and totally changed what the transcript meant. Okay, so anyway, Everybody's like swearing that their version is facts. Okay. All right. So moving right along. Oh, and on that, you guys, don't forget to like, subscribe, comment, leave me a super chat, especially if you want me to read your question. And we are moving in on 2,000 subscribers. I can't even believe that, you guys. Thank you for supporting the channel. All right. So the next thing is now the jury sees it. The transcripts are not released yet. Now the jury sees it. Even the evidence that the jury saw, okay, is different from what the public sees. The reason is because, one, the jury may have seen physical things that cannot be released to the public. Meaning, in the courtroom, the jurors may, for example, have seen the sweatshirt. It may have been out on the table. But when that evidence is released to the public, it's a picture. Right? I've heard, and I don't know, we'll know when the transcript comes out, but I've heard that people were interacting with the video with a pointer saying that this is what this person did, this is what happened here, this, right? We don't see that as the public. So it could be that the judge seals it, right? Let's say that the jury was shown some sensitive information, or was in fact shown the FERPA information, the files. The judge is not going to release those files to the public. Okay, so stuff falls out even there. Okay, so the last thing is that what the public sees is also edited by the news media, by the trial watchers, by YouTubers, by, social media posts and all that kind of stuff. So these are all the places where this evidence vanishes, right? What may have started out as like 4,000 pieces of evidence, by the time it's released to the public in that little file, it's what? 6 little things, a couple PDFs of images, 10 video clips, right? So we don't know. Okay. Thank you for the super chat, Nova the Great. Love that. Nova the Great. Are we to believe all of the witnesses lied on the stand? So I will tell you this. No, I don't think they all lied on the stand. I will say that I do anticipate and have heard from people who were there. I don't know, again, because any aspect of the testimony is second or third hand. I do have reason to believe, just based on my experience, that there probably was a lot of conflicting information in the witness testimony. So do I think they all lied? No. Do I think they all observed different things? Probably. Now, listen. Juries and courts give a lot of leeway when they're talking to witnesses who observed something significant that happened very quickly, right? They may not be lying. They could just be wrong and be telling the truth. And the way that happens is, right, you'll hear of a case where there was a violent crime that happened in the middle of a shopping mall. And when you talk to the people who were there and they're actually trying to be helpful, one of them will say, oh, he was wearing a red sweater. Someone else will say, oh, he was wearing a purple sweatsuit. Someone else will say, oh, the weapon was black. Someone else will say, oh, the weapon was silver, right? And they're all telling the truth. So I don't know what to make of it. I will say this, Nova the Great. I will say that I do believe that the peer pressure, if not affirmative pressure from Mr. Metcalf, and based on how I've seen him behave, I would not put it past him. But I don't know. But even if you take that out, the pressure that these kids must feel to be loyal to their school, to their team, to the big football captains is immense. So I believe they certainly had an incentive to lie. The third thing I'll say about that, Nova the Great, is that I do believe that when people start talking about their stories, their recollections start fading together. I always tell this story about my best friend and I. We've been best friends for so long that sometimes when we remember stories, we honestly cannot remember, did that happen to you or did that happen to me? Which one of us dated that jerk when we were in high school? Wait, did your mom say that or was that my mom? We literally cannot remember. Like, we have been sharing each other's lives for so long. We have been sharing each other's lives for so long that our stories are all the same story. Right? And that's the third thing I will say. That absolutely does happen. Okay. Thank you for the question, Nova the Great. Okay. I see another super chat. Thank you for the super chat. Soldier for God. Amen. Amen. $5. Thank you. Appreciate that. Appreciate the super chat. Oh, another one from Nova the Great. Thank you. I just subscribed to you. You sound non-biased. So I appreciate that. And I will say this because I do try to be non-biased. I do want you guys to find your own opinion. So I tell you what the rule is, what the law is, what the strategies might be. Now, I have my own opinions about what happened. My personal opinion is that a lot of this looks rushed. It looks sloppy. Things look like they are missing. They may or may not be. But if the trial were open and public, like this, all this arguing that people are doing back and forth in the chat, what did the witnesses say? Was the knife in court? We don't know. People are saying this, all of that would be eliminated if it were televised, right? Just like the Kyle Rittenhouse case. You may not like how it went, but we don't have to argue about who said what on the stand, who did what, right? So, and even the judge has said that he may have erred in not allowing it. He may have made a mistake in not allowing the trial to be public. People feel that it was very rushed in terms of how it went from opening arguments to closing arguments to the verdict, to the conviction and the sentence, to him being in jail in the course of like 24 hours. So I do try to be biased. I mean, I do try to be unbiased, but I do have my own views. But I also see that there are some. If you guys haven't watched it, and people didn't love this video, but this was a good video. If you guys have not watched my video about how to pick a good lawyer, one of the things that I said was that you need a lawyer who can point out to you the strengths of the other side's argument, their strengths and weaknesses, and your strengths and weaknesses, right? If you go to a lawyer and that lawyer is just like, oh, I do these cases all the time, this is going to be easy, this is a walk in the park, they set you up, they're trying to take you down, another black man, right? Whatever it is, you need to run. You need to turn around, put your hat on, and run, because they're not telling you what you're really up against. And then you walk out of there with 35 years and you're like, wait, what happened? What just happened, right? Okay. Let me talk about these videos. This footage. And I'm going to leave up here the 7 things that you're looking at. You guys tell me, just by typing in a number, where do you think the footage, the real true footage, fell out? Do you think that it was in fact collected by the law enforcement and they cut it? Do you think the prosecutor had the full file and just only disclosed a little bit? Do you think it wasn't all admitted into trial, right? If they had admitted, it's possible, right, that this judge, and I don't know, it's possible that this judge said, I'm not going to have this jury sitting and watching 12 hours of footage, right? And if they showed every camera angle, the same 20 minutes from every single camera angle, that might have been 12 hours worth of footage. And the judge may have said, we're already on an expedited schedule. You need to get that video down to the relevant time points. We don't know. The judge may have said that. Maybe the prosecutor didn't. I don't know. Okay. Also, it is possible, even though this is not quite, no icons. What does it say? MC Lot TV. Oh, MC Lotto TV. No, no crustaceans in my comments. That is disgusting. But yes, him. It may be possible that the jury saw more, and for whatever reason it wasn't released. We don't know. I'm going to do a reaction to this tonight if it's okay. I love your breakdown. Yeah, I appreciate it. And send me a link to it. Let me know when you did it. I have a hater. I don't know if he's in here today. I have a hater who he's done reactions to a bunch of my videos, and according to him, I'm so stupid. I'm such a moron. I'm such all this stuff. But yeah, go ahead. I have it set that you can do a reaction to it. Thank you for letting me know. Right. Okay. So someone said that they think that the footage disappeared at the very beginning. I don't know. I don't know. Okay. So let me see. Did I have anything else I want to show you guys? I don't think so. Okay. So there's another couple things that I want to make sure that you guys understand. Okay. There's a difference between the Brady obligations, which are the law of the land because the Supreme Court has said that it is the law of the land, right? Prosecutors must turn over this evidence, and then subsequent cases by the Supreme Court have sort of expanded the understanding of what that means, right? So subsequent cases said, not only do you have to turn over exculpatory information and evidence that tends to impeach the credibility of prosecution witnesses, subsequent cases added that this is an affirmative duty, meaning the prosecutor has to turn it over even if the defense does not ask for it. They also added that it's an ongoing duty, meaning whenever the evidence arises, even if it's in the post-conviction phase, the prosecution has to turn it over to the defense because that could be grounds for a new trial or an appeal or something, even 10 years after the fact, if new evidence comes out. So it's affirmative, it's ongoing. So those are the Brady rules, and they come from the court. Then there are the rules of evidence, which dictate what is admissible into court, right? Because something can be discoverable, meaning that the defense or the prosecution can ask for it, but it's still not admissible in court. So remember, I said that if the prosecution and the defense can't agree on what the prosecution is supposed to turn over to the defense, if the judge has to decide, the judge may decide, yes, this needs to be turned over to the defense. But later, when the defense tries to enter it, the judge could then say, oh, but it's not admissible to the jury. Right? So the judge really has multiple cracks at a lot of this evidence. Does it have to be turned over? Yes or no? And then if it is turned over, later they can say, is it admissible? Okay? So don't confuse what we see with what even the defense saw, because I'm sure that the defense saw more information than it was able to get in front of the jury. I don't know. Okay, let me see if I can. Okay, I'll tag you. Thank you. I appreciate that. Oh, I'm sorry, you guys. Just my ADD flaring up. All right, I was going to talk about this video. Okay, so there is this full body of footage from the school, and then there's probably footage from the students. I am not a person who believes that there is no footage. I don't know whether the police collected those cameras and found the footage. I don't know if they did not. I don't know if they did not collect the footage. I don't know if they were prohibited from sharing it. I don't know if they were included on a gag order. I don't know if they were told by the school not to share that footage. I don't know. But you can't tell me that there were not, that in a group of 20-something students, that nobody had anything recorded. I just don't believe that. Some people do. Now, what we also don't know is whether or not, again, the defense may have that camera footage, but perhaps it still wasn't admissible. We won't know. We won't know until it comes out. Okay, so this is what I think happened with the school's footage. I believe that there's more footage. I believe that the school took the first crack at narrowing it down. If you weren't on my video, I don't know, maybe 2 or 3 days ago, I talked about the 5 hands that footage would have gone through. The first person that would have touched that footage is whoever the security person who monitors the machines, right? That person. Then their boss, the head of security. The next place that footage would have gone would have been to the district's legal department. From there, they would have decided what they felt needed to be turned over. Then they would have turned that over to law enforcement. Law enforcement would have turned that over to the prosecutor. Now, it's possible that law enforcement and the prosecutor are one step, right? Sometimes they are, sometimes they're not. The prosecutor's office always has its own investigators, but sometimes they also have police investigators, right? So, if right, so we've got the low level security person who was operating the machines, right, changing out the video cassettes, or whatever that person's job is. Then you've got the head of security. Then you've got the head of the legal department. Then you've got law enforcement / prosecutor. Then the prosecutor would have edited the film to decide what was helpful to their case, right? So we don't know how many times this thing potentially got chopped up, 5 times before it got to see the jury. It's possible that the defense maybe tried to subpoena the whole entire footage. The defense may have gotten the entire footage. We don't know. All we know is that little pieces that got released, and even those were different from what the news station showed that night on the evening news. And I didn't realize this, right? So I found what I thought was a reputable channel, which was, I think, Fox 5 in the DFW area. Fox 4, I think, sorry, in the DFW area. And I went live about it, analyzing it as I saw it. But then after that, I started hearing people say, well, I saw a different video, or I saw this, or I saw that. And I said, wait a minute, how many versions of this video are there? And then I started looking at other news channels, and they were all showing slightly different pieces. So then I said, wait a minute, there's a source that all of these news stations have edited. And anytime you edit a video, it's editorial, right? So channel 4, channel 10, channel whoever, they got it, and they all edited it for their viewers. So when I went back to the main viewer, the main source, there were only 10 videos released, and they all picked up in the middle of the action or in the middle of something, right? None of them started that morning when the field was empty. So even that was editorial. Okay, I see a super chat here. Let me go up. Okay, Nova Degrade. What does FOIA get a regular citizen in this case? What is FOIA? Update that for me so I can answer your question, Nova Degrade. FOIA. You guys get me with these abbreviations. My mind is looking at so many things over here that my mind, I don't even know. There was a guy from Nova Degrade. If you're still here, update me. What does FOIA mean? But there was a guy who there was a guy from what was that? I think Law and Crime. Oh, this guy. And here's the thing. People really look to Law and Crime as like a very reputable news source. And I do too. Until I heard this guy, and I think his name was Cody Thomas or Cody Thompson or something like that. And I literally heard myself like yelling at my screen. Freedom of Information Act. Okay, let me back up then. Thank you. This guy, he just felt like he was so pro, what's the kid? Austin. It was like his tone, the things he chose to highlight. I don't know. It just bothered me a little bit. Okay, so what does a Freedom of Information Act request get a regular citizen in this case? So it looks like, so for those of you who don't know what a Freedom of Information Act request is, and they have different, they're called something different in every jurisdiction. Basically, it says that anything that is paid for by the government or uses government funds has to have public records, because technically they are paid for by the public. And so things like meeting minutes, intersection footage, election results, all kinds of things, anything that's created with the public money, the public can request to review the records, to see the images, to read the documents, right? Whatever. However, not everything that a person requests is automatically granted. Okay. So for example, there are exclusions if it's also paid for by other things that the public doesn't have access to. That can be an exclusion. The request can be too onerous for the delivering party. The request can be deemed a nuisance request. So what I've heard, and I don't know, but what I've heard a number of people say is that they put in requests to see the footage, and then from people who said that they saw the footage, they said that they were taken to a place and they were shown the footage on a monitor. It was not released to them and they couldn't control it. They couldn't touch it. They couldn't slow it down, speed it up, or stop it. But so they weren't allowed to have it, but their right to view it, to see it, was honored. So they went in, they looked at a monitor, and the video just played. So that's all we know that they got. Here's what we know that a regular citizen cannot get in the Freedom of Information Act. A regular citizen cannot get those student records. They can't get health records. Generally, they can't get tax returns and information like that. Also, a lot of discovery can't be gotten, and I'll tell you why. Because that's an easy thing to get out of, because it will be considered an onerous request, right? You can hand over thousands. I heard of a case recently with 3 million. I don't know if that was Epstein or whoever it was, but I certainly know of plenty of cases where at least 1 million or 2 million documents are turned over, right? So they're not going to prepare that for everybody who wants to see that. I hope that answers your question. Nova to great. Thank you for the question. Okay, so let me scroll up and see if something. So let me just say this. Someone said to me, I don't remember. I must have said, because I'm not a fan of Karmelo for not testifying. Now, again, that could be a part of their strategy. I think it is very, very wise for them to not have him testify if in the main trial, if they were going for a retrial strategy. That's very clever. If you haven't watched the Chess or Checkers video, go watch that. I talk about why Mike Howard may have not thrown the case, but sacrificed the case as a longer term strategy. But in response to a lot of people who are saying things like, Karmelo didn't do it, those two did it to themselves, one of them did it to the other, so Eddie did it, all of these other things. If anything like that is the case, that is a totally different defense from self-defense. And so I had said that I think Karmelo, one of my comments called me out on saying this. I don't remember exactly what I said, but I know I felt it, so I may have said it, that if Karmelo is not the one who did what we think he did, or what he's been accused of doing, I think that he's a damn fool, that he should have made it clear. He should have talked about it. That should have been a part of his defense. It wasn't me. That's not the weapon, right? But for some reason, people believe that this guy did not do this thing. Well, why hasn't he said it? I mean, was it why? What reason would he have to not say, I never sent anybody packing? It wasn't me. They're framing me. Like, why would he not say this? I don't know. So anyway, so when I think I must have called him a fool, and the person in my comments didn't like that. I just don't think it's true. I think he's pleading self-defense for a reason. Now here's what I will say. He said, I did it. Is there a possibility that he was admitting to something else, a different act? Maybe. But that's all a part of, I was confessing to something else, or I was admitting some other act. I wasn't talking about this. I didn't even know that had happened to the kid. I don't know. But he did say, what is it? I don't know. What is the it? Could someone make the argument that he wasn't saying that he did that act? I don't know. Does anybody in here believe? Let me ask you guys something. Would anybody be interested if I did a call-in show to have people call in and chat about this? I'd be interested. So someone says, and he also said, I know how this goes. Again, when you have pronouns, he could be talking about anything. I mean, if you wanted to go the direction of he is not the actual person who committed this act, the one of the things that you could use to back that up is that he spoke in he used a lot of pronouns, it, this, that. What does that mean? I don't know. That's the only argument, because he did a whole trial based on a self-defense claim. If he didn't do it, why wouldn't he say someone else did it? What's he afraid of? I mean, I'm sure he's not more afraid of whatever that is than he is spending 35 years on cell block D. Why wouldn't he say it wasn't me? So someone tell me, I mean, if you're one of the people who thinks that, and like I said, I don't know, but he's had a year to say those boys did each other in, or, Eddie, whatever, or I was set up, or something he could have said. But people literally are sitting here with this belief that one twin harmed the other, or I don't know. I don't know what that could possibly be based on. That's what I'm saying. If that's you, and people who feel that way are so adamant about it, that there's something. So my feeling is this: when Karmelo said some of the things that he said, and if you remember, Karmelo was very very polite to the police. When he said his name, he automatically started spelling it. I don't know. When people ask me my name without asking me to spell it, I don't start spelling it, right? So it said that he also never said that he was jumped. He hasn't really said much of anything except those weird things that he said to Officer Cortez when he was being handcuffed. But when he said, I know how this goes, what is this? Is it, I know how it goes when you have to search somebody's pockets when you put them in handcuffs? I know how this goes. He obviously didn't know how it went, or he wouldn't have even been saying anything. Right? If he really knew how it went, he would have been silent. But when he says, I know how this goes, what is this? When he says, I did it, what is the it? Right? Like Bill Clinton said, it depends on what the meaning of is. I don't know. It just, so for some of these theories to be accurate, you'd have to really quibble over what's the definition of those those pronouns. And I'll be honest, I'm all for it. I love quibbling over the definition of single words. But he for all we know, right? If people are true, if people are right, people who think that he did not do this, could the case be made that when he was talking to Officer Cortez, he was talking about a totally different thing? That he didn't even know that Austin had been sent packing, that he was talking about something else. He could have been talking about the left hook he gave him. Who knows? But some of these theories that people would have to really depend on parsing out these things. Okay, so let me just get back to my main point here. Just let me just wrap this up. And you guys don't forget, like, share, subscribe, participate in the chat, send a super chat. Let me just get back to this. Okay. Oh, this. Okay. We have to remember, because this video is about evidence, right? We have to remember that there is a huge amount of evidence that exists in the world. And the evidence that ends up in the case is a small subset of that. And then what gets released to the public is an even smaller subset of that, right? Now, we have to remember that some of the ways that this evidence goes away, right, doesn't make it to the final stretch. Some of it is perfectly legitimate. Some of it is perfectly legitimate. Others of it could be some malfeasance by the police, the prosecutor, the judge. I'm going to hold off judgment because I don't know. Has it happened? Certainly. We have certainly seen massive cover-ups. We have seen hidden evidence, pressured witnesses. We have seen lies. We have seen misidentifications. We have seen files disappear. We have seen, DNA kits go missing through malfeasance, right? Through some bad actor doing some act. So it does happen. But the number of people that it takes to affirmatively pull it off, and the number of people that it takes to not say anything when they know that's not how that file looked when I had it yesterday. What happened to all the fingerprints? They were there yesterday, right? Those people would all have to look the other way. Okay, True Advocate, thank you for the super chat. Let's see. It's the video, and the state's witnesses never claimed to see him take Austin. What if his attorney told him not to talk? Oh, I have thought of this in both directions, whether or not he was told not to talk, whether he wanted to talk, whether he was asked to talk and he refused, or whether his attorney, right? I go over that in my chess versus checkers video. I think, however it came that Karmelo didn't testify, it's a good thing. It's a good thing, right? If you guys have never heard me talk about this before, the fact that Karmelo didn't testify for whatever reason, if he gets the retrial, that will be fantastic. Here's why. Had he testified between the original trial and the retrial, the prosecution would have chewed his testimony up, broken it down into its itty-bittiest pieces, every possible contradiction they would have found, every piece of contradictory evidence to discredit and dispute his testimony they would have found. So when he testified again, if it were any different, if there were any inconsistencies between the two testimonies and anything else that he said that was consistent, even, they would break it down completely, which is what the defense is going to do to the prosecution witnesses during this time between now and the retrial. And you can believe that some of these witnesses will not be recalled. Some of these witnesses will not be recalled either because their testimony will have been disproven or because they won't be able to keep their story straight. They just will not be recalled in the trial because the defense counsel will be ready for them. So to answer your question, True Advocate, I don't know if his attorney asked him to talk and he wouldn't, or if the attorney told him not to. So it's the video, and the state's witnesses never claimed to see him stab Austin. Yeah, I mean, I don't know what was testified to on the stand, but it is very possible that in that crowded area that people saw the fight, but didn't see the actual poke. It's very, very possible. Thank you for the question. Okay. Oh, Nova de Great. What would cause more okay, hold on. Sorry. Nova de Great. Thank you for the super chat. Let me see here. What would cause more attention? Him being beat up and him having bruises all over him, or him stabbing someone and running away? What would cause more attention? I don't know. You mean what would cause more attention in the stadium that day? Is that what you're asking? I don't know. I thought young kids now, when they had fights, someone was always like filming it, A, and B, someone else was like world star. I don't know. Okay, if that didn't answer your question, give me some clarity. When you say what would cause more attention, do you mean under the tent in that are you talking about the commotion? I think maybe you're talking about what would have caused more. I don't know. Help me out with that one. Okay. All right. So let me just say this. So someone said Karmelo immediately spelled his name because everyone thinks it's spelled with a C, like the basketball player C, Karmelo Anthony. That's true, and you notice that the officer took it down as a C anyway. He had already made that connection. Yeah, I think if someone, so this thing about him being jumped, I don't know, when I think of the word jump, the way the jumped is used in a lot of ways, right? Like when I think jumped, it almost feels blitzy, like you're walking down the street and then boom, all these people are on you, versus a fight that starts out with two people and then another person joins in and then a third person joins in, and by the end of it, it's a 1-on-4 fight or a 4-on-1 fight, but that may or may not be the same as being jumped. I don't know. It definitely looked to me like there was chaos happening under that canopy, if that's what you're asking, Nova the Great. Yeah, I think a brawl in there would certainly cause more commotion. I don't know about the bruises though, because I don't believe he had any bruises. I haven't heard that. Anybody else heard that he had bruises? His clothes didn't seem to be ripped. I don't know. I think there was commotion. When I think of jumped, and maybe I'm wrong, maybe this is an old-fashioned thing, but when I think of jumped, sometimes people go looking for a person to go jump them. Like, oh, let's go find, Betty. Let's go jump Betty. Let's go jump Bob. As opposed to it escalating. That to me is not a jump. That's just a fight or a brawl or a 3-on-1 or something. I don't know. I don't even know if it matters. Okay. E.L. Summers, our future lawyers of the comment section. Thank you for the super chat. E.L. Summers says, Hunter should have been called. Okay, let me get into that. Mike wanted Melo to take a plea, said he knows judges and prosecutors. Mike didn't want to litigate he wanted to mitigate. I like that. Yeah, I don't know. Tell me, E.L. Summers, how did you know that? How did you hear that? Did Dominique, what's his name? Dominique Anderson. Did he say that? I think I heard someone say that. You never know. I'll be honest. Mike Howard to me does not look like a real, rabid, type to go mano a mano in the courtroom to me. But people will surprise you. But yeah, he doesn't look like he was ready to duke that one out. Or maybe he just got so exhausted in the very early part of it. I don't know. But I think if the judge really struck down as much stuff as it looks like the judge struck down, Mike would have seen the writing on the wall pretty early. He would have seen the writing on the wall pretty early. We talked about in my last video about how his very earliest subpoenas appear to not, at least 2 of his earliest subpoenas appear to not have been granted. Whereas the prosecution, they submitted like 30 or 40 subpoenas and all of their applications got approved. So Mike would have seen the writing on the wall. Thank you for the question. Thank you for the comment. He didn't want to litigate. He wanted to mitigate. Oh, I was going to say something else. What did you say about, Hunter should have been called. Here's the thing. Here's why Hunter and Karmelo probably were not called. Hunter would not have been called because it might have opened him up to, if he had said one word, one misstep in his testimony, he would have allowed the defense to ask him all kinds of questions about him and his brother, about the allegations against them. And he would not have been able to put that horse back in the stable, so to speak. And a good lawyer would easily outfox a 17-year-old kid on the witness stand. And all of that background would have come in and they couldn't risk it, right? The other thing is that the jury already had Hunter's testimony from the videos, from those videos that he did on the same day. Of course, the jurors had seen those, right? So putting him on the stand would not have added to that. It would have opened him up to the risk of saying something and running his mouth, or even, I mean, I've seen one or two words that a witness will say that opens up the door to a line of testimony that they can't handle, and that is not helpful to the case. So they had no reason to put Hunter on the stand. He wasn't going to add anything that the jurors couldn't imagine. Like, what was he going to say? Oh, my brother, you know, I lost my brother. It's so sad. The jury already knows that. Anything else he said would have opened the door to too much. That's why I think Hunter didn't testify. I think Karmelo didn't testify for other reasons, but I don't know. Okay. In his official mugshot, he has a laceration over his right. You are on it, Jess. This is a super sleuth correspondent in the field. In his official mugshot, he has a laceration over his right eyebrow, a red right eye, and swelling below his right eye. I didn't believe it until official pics came out, but it's true. Yikes. Yeah, I mean, that would tend to show that there had been some physical altercation more than grabbing his backpack and throwing it, which was like Austin's official, which was Hunter's official version. Okay, so someone asked earlier, I don't know where it was, but someone asked about, there was a copy of a message. There was a copy of a message from a cheerleader, a varsity level cheerleader. And apparently she was writing a message. I've heard of it as an email. Apparently she wrote a letter to an email to the coaches, and she basically said that Hunter behaves badly. And one of the things that she said is, I don't know what causes him to have these rages, plural, these rages. And she was saying, but it's getting very difficult for the cheerleaders to cheer on these football players. I mean, assuming it's true, I don't know. It could have been eliminated for any number of reasons. One of which, if the judge had said that that's more prejudicial to the victim than probative. It also, in the timeline, remember the timeline I showed you guys? It also looks backwards, and the prosecution always wants to look forward. The prosecution wants to look at the event and forward. If they have a victim with a bad background, they don't want to pull up old documents. They want to do everything that they can to keep those documents out, and the judge would agree with them if it's a conservative leaning judge. They don't want anything that's going to muddy the waters and make people feel compassion or feel a soft spot for the defendant, or that would make them feel disdain towards the victim. So that would be ruled out as more prejudicial than probative. Okay. Someone says, you can't say they jumped him because on his way to that squad car, he says, I told him, don't put his hands on me, implies one person. So, and a lot of people feel this way, and it's possible, but there is another way to look at this. That could be the one touch that started the altercation. He also could have focused on that one person because that one person is the one that he is told is injured, which the coach may have, or a class, or someone may have narrowed his attention to that one kid, or that could be the one kid that he did the act to, which doesn't mean that other kids weren't involved, that other kids weren't also throwing blows. So the fact that he said that to me it's not as dispositive as people are trying to make it out to be. There's a lot of scenarios that could elicit that statement other than I was only fighting one person and I did it. That's my take on it. A lot of people are saying that, but a lot of people are saying he wasn't like, oh, they put their hands on me, or, you know, there's a number of reasons why he could have used the word he and still have been fighting for people. Okay. Karmelo had bruises and they weren't in the police video that was shown to us. We need to see the untampered with version. Agreed. And again, no matter what happened to that video, no matter who edited it, it happens very early in these, right, of these 7 steps. It may have happened very early on. I don't know. I can't imagine that the defense did not have the original videos. I can't imagine that the defense did not have access to the same video file. Meaning, I don't believe that the first video that the defense saw was an edited video. I can't accept that. I cannot accept that. If it is, God save us all. If the defense counsel was happy with an edited video, I have no words. I'll just say that. I have no words. Okay. Okay, Nova the Great. Thank you again for the super chat. I appreciate you tonight. Y'all are missing the fact that he told the coach what he did. Again, that is testimony, right? Do we have any, Nova the Great, do we have any proof of what was said between the two of them other than what was elicited in this transcript that we haven't all seen? I've heard that the coach said something to him like, something like, you do know that the rest of your life has changed, or something like that. I don't know where that came from. I don't know where that came from. So all of this stuff is alleged. So actually, the word alleged, people say that the word alleged is used until the trier of fact establishes what the facts were. And then it's no longer alleged, meaning that once the jury rules, it's not alleged. Once the judge rules, it's no longer alleged. Now, I am not a believer of that, because I think judges and juries do get it wrong. Sometimes they don't even need to resolve all of the facts to make their decision. Like, does it really matter whether it was a shove or a push? Does it really matter whether it was the left hand or the right hand? Like, we don't need to resolve those facts. And those are example facts, not related to this dispute. But traditionally, that's what the word alleged has meant. That right, like this alleged criminal. Once you've been convicted, you're no longer alleged. It's true now. Right, that it is the job of the trier of fact to determine what the facts of the matter are, and once they do, it's no longer alleged. All right. Just think, if Austin wouldn't have got hit, it would have been Melo, probably. Yeah, that's true. One of the things that I talked about on some video is the thing about self-defense, right? Self-defense is all about what would have happened in the moment right after the defender self-defended. If you believe that what would have happened in that very next moment would have been detrimental to the defender, then you believe that self-defense was warranted. If you believe that what would have happened in that very next moment would not have been detrimental, then you believe the defender overreacted. So yeah, so that becomes the question. What if he hadn't done that act? Who knows what would have happened? He could have had his neck broken. He could have, he could have been the one with a poke in the chest. Or he could have got mushed in the head and totally overreacted. Who knows? But that's the question. What do you think would have happened next had he not? Right? Self-defense is it's like an intervening act. It stops the flow of what was about to happen and redirects it. So the question is, what do you think would have happened next had he not did that pattern interrupt? So all the other witnesses lied about the situation. So all the other witnesses lied about the situation. They all got together, people of different families of witnesses, to come up with a consistent lie about the situation. Okay. So, all right. So okay. So they could all have different stories and all be telling the truth. I've explained that a bunch of times. I think they could all be feeling similar pressure, and based on what I've seen from Mr. Metcalf, does not surprise me. But also, who gave me that comment? Zenzelli. Yes, there have been cases where entire groups of people, yes, right. These are the classic cases where someone gets sent packing during a sleepover. There's 15 people at the sleepover party. For 30 years, nobody tells what happened. For 30 years, they all agree to blame it on one person. Yes, there are things that happen in sorority houses and fraternity houses, and they take those things to the grave with them. There are things that happen at family reunions where there's 120 people there, and they all lie. Yes, that does happen. Whether it happened here, I don't know. We'll see. But I mean, I'm hearing a little bit of sarcasm in the comment, but yes, it does happen. It absolutely does happen. All right, you guys. So, I'm going to wrap it up there. I just wanted to show you guys that there's a lot of places, both legitimate and shady and suspect, where evidence can fall away. I also want to remind you guys that just because it wasn't released to us last week on the court's website doesn't mean that the defense didn't have it. It doesn't mean that the jury didn't see it. It doesn't mean a lot of different things. So we don't know and we won't know. The only people who know right now are the appellate attorneys. They will see all of the motions that were made or not made, all of the requests that were made or not made. We don't know whether or not there was a request for a venue change. People said that Collin County wasn't even the right county. I Googled that really quickly. 4 different places confirmed that Collin County. What we would have liked to have seen was for Mike Howard to make a motion for a change of venue out of Collin County. But people are implying that Collin County wrongly picked it up, that it should have been in this Denton County. Quick search dispelled that, right? The facility is in physically, geographically in Collin County. Whether or not there was a motion for a change of venue, we don't know. Only the appeals attorney will know this until it's all released. So, okay. Oh, Polynesian Power Network 115, really good live, great work. Thank you. All right, you guys. So we've been here over an hour and a half. You know, I can go on all night, but I don't want to hold people unless there are other comments. Okay, someone said, I love how they don't want to look backwards when it comes to disparaging the deceased, but they always do when it comes to Black people, except in Karmelo's case when he saved a child's life, right? And was a 3.7 student and was a multi-sport captain and had a job and, right? All of a sudden that stuff doesn't count. You're exactly right. You're exactly right. But if he weren't all those things, yeah, his juvenile record would have come out, you know, yep, all of it. Absolutely right. On surveillance at 9:53 HM, Hunter Metcalf is seen getting up from his seat to walk towards KA. Okay. There you have it. Yeah, there's a lot of people are saying from the footage of when he first entered the tent, that he went directly up to Karmelo. Some people are saying that Austin and Hunter had changed places and that was actually Hunter that entered the tent and made a beeline straight for Karmelo. On one of my earlier lives, we tried to dissect that video. I could not see clearly that Hunter and Austin had changed places. And even if they had changed places, if you guys remember when they were approaching the tent, people think that Hunter, who had been in the back, ran up, overtook Austin, and actually was the first one to go into the tent. The thing is, I couldn't make that out. I did see him run out, but the whole team, first of all, part of the reason you couldn't tell any of these kids apart is because they were all wearing black, because the coach had sent out that message telling everybody to wear black, right? So all the kids were wearing black. But if Austin overtook Hunter, I personally could not make it out in the video, and we played it at least 3 times. I couldn't make it out. But also, even if the one in the back did overtake the one in the front, we don't have any information that between when they entered the facility, where Hunter was clearly in the back, and the time that we caught the back one running up to the front, they may already have switched outside of our view and were then switching back. So I don't know. I don't know what to make of that. His life was in danger, so he said. Okay. Hunter is not that bright. He definitely would have said, we made a mistake. LOL. Okay. I don't know what that's about. I appreciate the LOL because I was going to be like, well, now, wait a minute. Would he? But I'm assuming that's a little bit of sarcasm. I don't know. Okay. All right, you guys. So I think this is all. Let me see here. What's with them wearing the same outfit? Okay, yeah. So I just spoke to that. The coach told them all to wear black. The defense attorney was crooked. You guys, here's the thing. I think what actually Mike Howard did will not be made clear to us for some time. Either he is completely incompetent, and I hate to say that about another member of the bar. Either he is completely incompetent, he was in over his head, or he is still playing chess and outfoxed everybody. Because he did, one of the things that he did that was amazing, again, was not putting Karmelo on the stand. That is going to be a major, major, major asset in their favor when they get this retrial. And I do believe they'll get the retrial, personally. So I don't know, but what Mike Howard did, if he didn't get paid and he secretly, quietly quit, it will all come out in the wash. It will all come out in the wash. So I don't even know. But it looks rough. All right, you guys. Thank you very much. I was gonna say enjoy your weekend, but here we are. It is only Tuesday. Wow. Okay. I was at the beach yesterday, so I think my days are a little off. All right, you guys. Thanks, everybody. I'm gonna shut it down here. Have a good one.